I am told, no, that can't be done. It's 1,62,000 as far as this particular party is concerned. It's very, very important. Hard-earned money, you cannot nullify it. So therefore, the constitutional elements come in. 300A, of course, 19(1)(g), 14, proportionality, and livelihood, which we'll come to, on life at any rate. But we'll deal with that at an appropriate stage. And the final thing which I'm just mentioning in this particular compilation, we've actually separately e-filed another compilation, but e-filing I've also given a physical copy. You needn't turn to this. Here, you needn't turn to it. But I want to just mention one thing, what the Reserve Bank of India said. The Reserve Bank of India said that that 16,000 crores worth of these notes, which are the specified bank notes, the value of which was specified, 16,000 crores worth was left outstanding. That is what their statement said on 30th August 2017.
What do you mean by that?
All right. So what they said, so your Lordship recalls that at the moment demonetization was announced, there was a window given for exchange of those notes, etc. So basically it fell under two schemes. The Prime Minister very fairly said that, look, the last date is going to be in December 2016 itself. However, for appropriate cases, there will be some extension which is to be granted. That was obviously consistent with the government thinking and policy at that point of time. Thereafter, on 30th December 2016, they introduced an ordinance which said that, sorry, the last date is not going to be anywhere in 2017. It is going to be 31st December 2016 itself. And we are not going to allow any extension, though the ordinance provided for that provision under Section 4, which this court asked the central government to file a reply that, look, are you planning to exercise this power under Section 4 or not? So that's a separate issue. Now what happened? So to answer the question, what the Reserve Bank of India said is that all the currency notes which were cancelled, I'm just using the expression cancelled, or the specified bank notes of 500 and 1,000, which they have received back, it constitutes 98.96% of the notes which were in circulation. But 16,000 crores worth of notes are still outside. This is Reserve Bank of India's statement. Out of that 16,000 crores worth, there may be some which are, which don't justify any leniency or any extension of benefits by the government because they may be unauthorized. So we are not talking. But in genuine cases like mine, where I was overseas, I came back, I have full disclosures. Even those people, in my case, 1,62,000 are completely shut out. So I'm left with holding these particular notes which are of no value. And thanks to the Attorney General's statement which he made, which I indicated to your Lordships, we are not being prosecuted. Our notes are with us. We are before this court on this issue. Very important. It's not just some abstract principle. As far as I'm concerned, it's a question of my hard-earned money which has been rendered naught. So that's the issue. So, Manoj, these dimensions are far from academic. They are very, very much alive. And Manoj, I think Mr. Chidambaram will have on the larger issues a lot further to say.
Your Lordship's last question.
Only,
Yes.
Shyamji,
Yes,
before
yes.
Chidambaram starts, that money is still with you without any value, even.
Yes, exactly. It is still with me. And so the answer is yes. It is still with me. In my application now, I have given the specifics as to how many notes of 500. Really requires a full hearing, Manoj. Having got us all to come over here and make these submissions. Now, please don't tell us that it is academic or send us back to some other court. Because your Lordship, see, they move transfer petitions from across the country and wherever else. We've all come over here now and we waited. So now that your Lordships are sitting in a panel of Constitution bench, 5 judges, I would respectfully submit that, it's not going to take very long. I'm sure even on the merits, we will not be taking all the great lengths of time And far from wasting the order, I mean, the time of the court is, I think, going to be very beneficial, because the guardrails eventually are set out by this court as to what governments can do, what executives can do, and what they can't do. Grateful.
Only one interjection, my lord. Since, my lord, hard-earned money, this, that, and others, that is also taken care of by the Act Section 4. Possibly, there must have been application made and rejected. Possibly, we'll check up. So it's not that hard-earned money, my lord, is taken away.
Made and rejected, is it? Made and rejected.
Possibly, we will have to check up. So it's not as if hard-earned money of everyone goes. There are statutory protections given that you can convert it.
And to
And
answer,
the government, obviously, my lord, would be fully aware of this situation. I didn't want to interrupt, but he said hard-earned money taken away. That's not good. That's
to answer the submission that the 1978 Act, those writ petitions of individual cases were considered by the Constitution bench for good reasons. Kindly turn to page 109 of the order judgment of the Constitution bench. There was an appellate provision under the Act. Appeals were filed. Appeals were rejected. Thereafter they came to the court. Therefore, they were heard again. So it's in an entirely different context, not because the petitions are being tagged along here, they have a right to be heard. So if the
Petitions have been tagged at your instance.
the what I'm trying to point to, there was a reason why they were heard.
Petitions have been tagged at your instance.
Because you didn't want it to face the music throughout the country, that's all.
There is very important reasons. Very important reasons.
Lord, I was there, my lord, therefore I can say, not face the music. My lord, the idea was there were conflicting orders being passed, interim orders being passed. Therefore, we say that this is a pan-India issue, let the Supreme Court take it. That was the issue.
A matter of moment at that point of time. Therefore, the orders are being passed. So I come back to those 11 questions, the 9 questions. In my very humble submission, many of them are academic. I repeat that statement. If you look at this question, what's the scope of judicial review in matters relating to fiscal and economic policy? I mean, one more chapter to be added by this court in a matter like this. And then again, the next question, whether a petition filed by a political party and the issue raised is maintained with Article 32, does it have any connection with this issue? Therefore, these issues probably are absolutely irrelevant to this point of time.
Mr.
So maybe
Attorney General, what at least we are thinking is, now the Act is in force.
Yes.
The notification is still in force.
Yes.
The notification issued under Section 24, right?
The Act is taken over.
26 operated already. What is the correct way?
No, operated means it has come to an end, is it? Whether it is time bound, the notification.
Yes.
No, was it for a specified period?
Because
Yes.
certain consequence follows on 31st of December. That consequence is already followed.
Therefore, it has worked itself out.
Maybe we
Therefore,
may
the
have to
Act
examine. We may
the
have
Act
to
now
examine.
occupies the field.
Maybe we may have to examine, Mr. Attorney General.
But then I would probably advise the court that there was limited threshold examination of what would be, if at all the court may have to go further in this matter. I thought a limited threshold examination.
What is
when
the prayer
essential
sought in the
core-
writ petition?
Your Lordship, please.
What is the prayer sought in, at least in,
To set aside the notification.
exactly?
That's right.
That notification
Therefore,
is still
today,
in force.
even if you set aside the notification, the act is in force. So therefore you can't have that's why it's an academic declaration.
No, in some of the petitions, the Act has also been challenged.
Act has been changed, like 24 and
So it
26.
won't become academic in that sense.
And above all, we can only say academic or infructuous, where both sides agree. But if there is a point and a counterpoint, you want to say whether it is infructuous, whether it is.
I quite see that. I quite
We'll have to hear it.
quite see that. But only the concern is, before going into the larger canvas which persuaded the government to enter into this very important exercise. I mean, to lay down before the court all those very important considerations taken by the government. And it certainly
That is why
persuaded the court that
the earlier denotification, though, if I am right, it is 78, is it, or 76?
no, that was
It's not examined in which year? 92, is it?
96.
18 years later.
We are the distinction between the 1978 Act and what's happening today, the very important distinction. A large number of developments in economic policy, banking policy, globalization, and impact of monetary policies across the globe. There is a large number of issues, corruption, black money, whole number of issues being taken into consideration by the government. Therefore, my only concern is to what extent the court will enter into all these
That
connecting.
of course we can decide only after hearing
hearing
both of you. We are not able to make up our mind right now, you know.
I understand. We are only trying
We are
to
not
flag
in a
the
position
concern.
to take
No, that argument is always available to you. What is the scope of our judicial review?
But
What are the limitations? So while examining their submissions, we'll always be guided by those principles.
I'm not restricting that at all. I'm not saying that at all. But only saying that my concern is the moment you want to get into any one of the issues, then there are further issues which keep cropping up. Therefore, I was trying to look at the issues. How many of them are academic today? Will the court go into all those issues at all? Probably that's why I said let's have some threshold
No, no.
for issues.
How can you say that?
Like to go into.
No, how can you say that issue number 7 is only academic?
No, it's not academic.
What is the scope of judicial review in matters relating to fiscal?
There are any number of your lordship's pronouncements on that. Any number of them.
Therefore,
Going back to your lordship.
therefore, in order to answer that issue, we'll have to hear and give our answer to it and say whether it is academic or whether it is not academic or whether it is beyond the scope of judicial review. See, the
Certainly.
point is, as I already said, the government policy, the wisdom of the government is one aspect of the matter. We all always know where the Lakshman Rekha is. But the manner in which it is done, the procedure is something which can be examined and an answer can be given. But for that, it is necessary to hear the counsel, learned counsel.
Certainly, so there is no resistance to that at all.
Yes.
I'm only repeating my concern that even the manner part of it, the procedural part of it, if the court may have to say, yes, the procedure was absolutely, inappropriate, ill-advised, then the court probably would enter into a domain where the wisdom of the procedure, followed, could also be a matter for declaration by the court. Therefore, in that context, how far the court would travel?
So any
How far
declaration,
the court would travel?
See,
Yeah, that's why these concerns are being flagged.
any declaration one way or the other, any declaration one way or the other is for posterity. And I feel it is the duty of the Constitution bench to answer it
Without
one way
doubt.
or the other.
Without doubt.
Yes.
But your lordships know that in certain momentous decisions taken by governments at given points of time, there are several considerations which are weighty persuasive.
Correct. While answering it, we would take into consideration those
Right.
considerations.
But by only
We understand your apprehensions.
Lord, today your ladyship or my lords may not conclude anything. Let it be heard on some day
Yes.
without, my lord, any further orders today. Your lordships, my lord, have the conspectus of the matter on both sides. We'll address your lordship.
To know whether there is a point and a counterpoint which requires consideration.
Yes.
No.
Yes.
Everything is in
So they should be satisfied.
Yes, my lord. Taken away suddenly and I have no remedy. While taking that decision, even the hardship to be faced by honest people like Mr. Divan's client, they're also taken into consideration and provisions are.
Because your lordship will recollect that every exemption which is given under this scheme creates a huge impact. People try to take advantage of that exemption. So it was important to confine the exemption to very narrow limits. Otherwise, there has to be one cut.
All right, what we suggest is let Chidambaram make his submission and let us see, we will see after some time and we will grant you time, there is no problem. But let him make a beginning, let us see how things take shape, right? Mr. Chidambaram, please start.
But our response, the learned AG and me.
No, we will grant you enough time, nothing.
You know, whatever I was trying to place your lordship, only with a certain amount of concern, you're opening a matter like this of large implication. We're not seen as, not inclined to assist the court. That's not, but there are concerns which unfold over a period of time. It is a point I want to be very careful about it.
But we have answers, our affidavits are in detail and dealing with every submission, which we believe you will satisfy lordship's conscience.
Yes.
Even they will not conclude today, probably only.
Yes.
The overview of them.
We will grant you enough time, nothing to worry. This can't be rushed through also, we know that also. But unless we make a beginning, how will you, Let us start, let us see. Yes, Mr. Chidambaram.
Very well,
Please.
I'm grateful.
Yes.
Well, let me indicate the scope of my arguments, a broad overview of my arguments. And whenever your lordship wishes to go into the questions more deeply, I will assist your lordships. So the first question is, does the government have the power under Section 26 of the RBI Act to make the notification which was eventually made on 8th of November? 8th of November. In my submission, the government does not have the power. This was realized way back in
Mr. Chidambaram, before that,
Yes.
if you can give some sequence of events to understand better.
All right, I'll tell you.
Just the sequence, what happened on what day, just a few,
Well, there are only 3 events to our knowledge, and none of the documents pertaining to those 3 events have been produced, which is one of my complaints, which I will address. According to the record, according to the counter affidavit, and according to what is available in the public domain,
Yes.
on the 7th of November 2016, government wrote a letter to the Reserve Bank of India asking for its recommendation whether 500 rupee note and 1000 rupee notes may be demonetized. The starting point, according to the record, is the letter from the government to the RBI. The RBI board, my lord, your lordship knows, consists of
What exactly is the query to the RBI? What exactly?
Please make a recommendation whether 500 rupee note and 1000 rupee notes may be declared as no longer legal tender.
That was
There is a
the
letter from the government to the RBI. Much turns on that. On the 8th of November, the next day, the RBI did not take even 24 hours to consider the letter. The very next day, the RBI board meets in Delhi, not in Bombay. It meets in Delhi. The RBI board.
What is the significance? No, Bombay or Delhi. What is its significance?
Mr. Sharma, please maintain the decorum. Please maintain the decorum. No, please don't interrupt the proceedings like this.
Then there will be one side only. I'm not saying anything. I'm saying only all the advocates.
You are interfering in the administration of justice.
They are extending just for nothing. And all the advocates, they are not only one advocate, they are all advocates are sitting and trying to see the court proceedings. They are helpless. Somebody should say, somebody should request them to be one side, that I am requesting them to be one side. Nothing more than that.
Oh, please, just disturbing.
Then I should take the assistance of Mr. Sharma.
See, for your information, we can't see the attorney from here, for your information.
I'll keep standing, Your Lordship.
No.
On the screen we can see one.
On the screen. There is no screen on the other side? No?
There is a screen, but I don't know
Oh,
whether.
that is covered.
No, that side they have a smaller screen.
There is a small screen, yes. There is a screen here.